lake. And so when my mom grew up there by the old windmill up
And you
there,
gotta
you
look
know,
at it, yeah.
if you were ever up there, but you might remember that.
Number that number,
And there,
this number that.
we just lived down the hill there on that.
Going up or down here?
Yeah,
And then just my family, my aunt. Yeah, good thing it wasn't even theirs.
Yeah. Mark.
I don't know.
Sling on.
I don't know.
Thanks, Wanda.
I'm not.
You gotta get to it.
No. Where is- We're good.
That's 6 o'clock, so we'll call the meeting to order. Notice was posted in accordance to Wisconsin statute 19.84 open meeting law. At this time, we'll ask the secretary to please read the notice of public hearing.
Notice of public hearing, State of Wisconsin, County of Burnett, Monday, June 1st, 2026 at 6 p.m. at the Burnett County Government Center in room 165, Town of Menan, Siren, Wisconsin, regarding the following. Variance 2611, Mizziki. Public notice is hereby given to all persons in the town of Rusk, Burnett County, Wisconsin, that Ronald and Deanna Mizziki have made an application relative to a proposal to vary the terms of the Burnett County Land Use and Shoreland Protection Code of ordinances as follows. To construct a shed at a reduced setback to a private road easement at 26867 and 26869 East Benoit Lake Road in the RR1 zoning district, Lot 1, CSM Volume 7, page 195, and a parcel described in document number 261801 in Government Lot 2, Section 33914. Variance 2613, Bergstrom. Public notice is hereby given to all persons in the town of Scott, Burnett County, Wisconsin, that David Bergstrom has made an application relative to a proposal to vary the terms of the Burnett County Land Use and Shoreland Protection Code of Ordinances as follows. To expand a dwelling cabin more than 25% on a parcel that is non-conforming for dwelling density on Nicoboyne Lake at 29518 South Nicoboyne Lake Road in the RR2 zoning district, Lot 1, CSM, Volume 2, page 31, in Government Lot 1, Section 34014. Appeal 2601, Town of Oakland. Public notice is hereby given to all persons in the town of Oakland, Burnett County, Wisconsin, that the town of Oakland has made an application to appeal the decision made by the Land Use and Information Committee in reference to Cup 2519, located at 28271 Ivywood Drive in the RR3 zoning district, Lot 1, CSM, Volume 30, page 43, Section 204016.
Thank you. This time we'll approve the agenda order. I'll make a motion to approve.
I second it.
Seconded by Schmidt. Any other information on the agenda order? We will note that 2612 is postponed. I'll say that when we walk through it too. If not, all in favor say aye.
Aye.
Opposed, motion carries to approve the agenda order. At this time, we'll go over meeting procedures. The hearing is being recorded, as you heard earlier. So we ask that only one person speak at a time. When your variance appeal request is announced, we ask that whoever is presenting in the case, that you will come up to the table, sit in the chair. You will then present your case to us. The board may ask additional questions during this process. Once you are done presenting your case and the board has no additional questions, you will return to your seat. The board will then open the public hearing. Those speaking during the public hearing will have a 3-minute time limit. When you are called upon for your public comment, please start by stating your name for the record. Make comments to the Board of Adjustment members only. No questioning or arguments between individuals in the audience. Any written correspondence received will be mentioned at this time as well. Once all the public speaking is concluded, the board will close the public hearing. The board may then follow up with additional questions for the applicant. The board will then deliberate the case amongst themselves, and you will likely have a verbal decision here tonight. The board may table or defer action whenever it concludes that additional evidence is needed or further study is required. If a decision is made tonight, then at the next Board of Adjustment meeting, the board members will sign the decision document. Once that document is filed in the office of the Board of Adjustment, usually within a few days of the board's signature, the 30-day appeal limit will start. Any person aggrieved by this decision or applicant, officer, department, board, or bureau of the county, town may, within 30 days after the filing of this decision in the office of the Board of Adjustment, commence an action in circuit court seeking a remedy available by certiorari. Any general public comments at this time? If not, we'll go into the hearings. At this time, we'll hear public hearing variance 2611. Berzicki, was that correct?
Close.
Close enough? Okay, we'll pass.
She hit it right on the money.
To construct a shed at a reduced setback to a private road easement. You'd come on up.
Well, it's both or this one.
Whoever's gonna present, yeah, typically just one or you got. And did you get letters from them today?
Yeah.
We read the letter.
I would need those for the file.
Yep,
You got them, Camp?
pass them back.
Sure.
Yeah, they came in last minute, just to put into the file. Yep.
So I'm just here to, I'm asking for a variance on the setback from the road, the easement road, going down to the neighbors' cabins to rebuild a shed. Well, I'm looking for. What else I can tell you? What is it?
And it's just a shed to store stuff,
Yeah,
lawnmowers, chainsaws, that kind of stuff.
lake stuff,
Okay,
tools,
I mean, nobody's gonna sleep.
unless the kids think they can, but is that a whole different?
That's a whole different can of worms. So it
The
was,
shed is what we planned on.
yeah,
But I have a tent right now. Next to the house and everything's inside that.
The only other flat spot, right?
Well, it's all flat, but just, that's where it was originally. This used to be a resort. And that's where the shed,
No, I mean where the tent is.
yeah, right next to the house.
Flattest spot.
Yeah. So it pretty much fell over. I took it down the rest of the way 12 years ago. And, just never got to it. My parents got sick and I had to take care of them. Now I'd like to get it done.
Looks like a decent foundation.
Yeah. No, it's not, I used to pour concrete.
There you go.
Lots of stuff.
It would be the same size as the foundation that's there now.
It's a little bit bigger than what was there,
Okay.
but not by much, like 4 feet to the back. I figured if I can go 2 stories, plenty of stuff to put in there.
How many other cabins will pass through and use that part of the road?
Use the easement road?
Yeah.
4.
For,
Yeah. Actually, it's 3 different owners down there. You have Barb and then you got Bob and Rusty own 2 cabins and then Bill and Jay own the last one.
So is it gonna be a one-story structure?
2-story.
Two-story structure?
Yeah, there's
In the
schematic.
plans that you have right here.
Oh,
Yeah,
okay.
they've sent everything in.
Yeah, I was looking, but these are only 14 feet across. So that's where's the two doors and fence.
Okay, yeah.
They end up with lots of toys and paddleboards and. Oh my cool.
I notice you have a patio door and a deck on the second level. But there's no exit stairs off of that.
I haven't decided which way to go from there.
Okay.
I'm gonna go down that way or come off to the side. My
So there is-
septic tank. The whole thing right there is clean out. I don't know which way I'm gonna go there. Didn't know you could move to the other side.
Any other questions for the applicant? Any information you want to share at this time that isn't in the packet?
Everything's in there.
And yeah, we did make note that you brought in 2 letters at the meeting that.
Yeah, they gave me this week.
No, understandable. We just want to know that all committee members looked at them, read them, gave them to Jason that he can add it to the file at whatever it might be.
There are 2 of the owners that are down below me.
Yep.
Barb's right next door and then Bob and the rest of your next door. And I think Bill sent one in. I'm not quite sure if he did.
Okay, that's it. If you can head back. Did you want to say something quick?
Did you receive any other letters in the mail from any other?
No, nope.
How many letters did you send out?
It's in the packet, the list them in the application that gets sent out.
Looks like 8.
8 letters?
To the immediate neighbors, that's it's
Well,
part of
that-
the application process. You fill out the immediate, we gotta notify everyone within.
But you only got 2 responses.
It's not.
That's more than normal.
Yeah.
20%'s a win.
Yeah.
We got those at home too.
Yeah.
I was curious how many responded.
Jeremy, could you just clarify what was in the letters since they're not in the packet?
Had 2
I'll
of,
just read them real quick.
Yep.
May
Thank you.
31st, 2026. Greetings. My name is Robert J. Sorensen. My wife and I own 2 cabins at 26857 and 26859 East Benoit Lake Road. We have 2 of the 4 cabins that use the access road that is up for the variance being requested. We both are in agreement that this request be approved. Thank you, Robert J. Sorensen and Carolyn P. Sorensen. Next one, 5/21/26, to whom it may concern, I, Barbara Allen, is owner of 26861 East Benoit Lake Lane, Spooner, Wisconsin, 54801. Do not have any concern with the replacement of the building in questions located at 26867 East Benoit Lake Road, Spooner, Wisconsin, 54801 by Ron Bazinski with regards to the distance to the road access to my home, Barbara Allen.
yeah, at this time, we'll open up the public hearing for variance 2611 versus. No, I didn't. Lost it. Did you say Bazicki?
Bazicki.
Okay, thank you. Two syllables. Any public comments from anyone in attendance? Anything, nothing else was added in the stuff, no letters from GR or behind the 75Z? Any other comments on public hearing for 2611? Lindsay? If not, public hearing is closed. The committee will deliberate amongst ourselves. Any concerns from committee members on anything, this one?
Only that good to have a permit ahead of time.
Like I said, you match that, this was existing foundation, we thought. That was there. And the building tore down,
Yeah.
yeah. Some of the issues that are in the permit is the distance to the road, that's the leeway there. And this is actually, am I not mistaken, this is the private road one?
Yes.
Correct.
So. No one from the town mentioned, any incursion of being close, obviously. We try to keep right of ways so we can access emergency vehicles and things like that, but looking at the tree lines on the property and where the stuff is, I don't
And
think
quite
that
a sharp hill.
the town's not gonna move the road. I don't see that happening on that easement side there.
And there's no garage door backing out onto the road.
The only issue I've got is with the vaulted ceilings, it seems like we're kind of bumping into the idea of a bunkhouse.
You would look at why you would want a sliding glass door in a storage facility. Yes, you can make that argument, but that's the application says storage. I don't know, or
No, we just, you need to be warned that that can't be. As it sits, it's a storage building, not a dwelling.
It could be a workout room. You can go up there and work out.
Correct,
you know,
but
right.
not a dwelling, and
Not a
we
dwelling.
see too many of these where somebody turns you in and then becomes a big mess of trying to get it to conform to uniform dwelling code after the fact, and it's a mess you don't want.
It's not gonna be a dwelling. It's not gonna be a stove and refrigerator.
There's just the two of us mostly.
You know where I'm going though. That happens a lot and it just turns into a mess later on. You said it's 4 feet longer?
4 feet. Probably 4 feet longer and 4 feet deeper, so
Okay.
from the original. The original one built.
Nope.
Yeah, the goal.
Because I don't see a big issue. Guess I'd rather see it 2 stories than twice the size. Doesn't have the room,
And you can't see it from the lake.
you know.
And like Dana said, that nobody's gonna run into it, because that bank is 12 feet high, and they're not gonna change the road.
Yeah.
So it's really not affecting any of the public interest whatsoever. And it's much better to have a building than having paddle boards and stuff outside or in the tent or whatever. Yeah,
And you saw the tent.
yes, sir.
That's a.
I don't have anything more.
Nope, everything's in the application.
I'll make a motion to approve Baziki variance number 2611.
Have comments?
Staff comments, there was 6. Land use permit to be obtained prior to construction. Structure not to be used for human habitation. Sanitary system evaluation to be done on the southerly cabin by a Wisconsin licensed plumber and submitted to the county by 8/1/26. Sanitary permit to be service maintained on the northerly cabin and submitted to the county by 8/1/26. Lock and chain to be installed in septic tanks by 8/1/26. And follow all local, county, state, and federal requirements for this activity.
I have a motion by Campion with 6 conditions. Do I have a second test to his motion?
Second it.
Seconded by Daniels. Any other discussion on variance 2611? If not, all in favor say aye.
Aye.
Opposed? Motion carries to approve variance 2611. Thank you. And variance 2612 has been postponed, so we'll move on to variance 2613 Bergstrom to expand a dwelling cabin more than 25% on a parcel that is non-conforming for dwelling density.
I'm going to recuse myself from this one.
Yep.
Evening.
Evening.
I'm Chuck Brookshaw, Rivers North Construction. I've been asked by Mr. Bergstrom to represent this evening. So thank you for hearing this application. On the property they currently have, they said, are aware of in the application that there are two dwellings on this property I don't know if you don't know, but their age. And what they're desiring to do is to remove the one and replace it with a new structure. There's consideration for adding on to that existing cabin, given the age and condition of the foundation, the overall structure, what it's not supposed to do. So we'd like to remove that and give them new structure. The existing cabin is just under 670 square feet, and the new one is I don't know, we have it as
1560.
Pardon me?
Well, the proposed addition structure is 1560 on.
Oh,
the-
I think that's.
Yep.
Okay, thank you. So in placing the building on the property, not looking to go any closer to the lake, it's already within the 75-foot setback of the lake. In respectable setback of the side property line, and would be looking to build away from the lake. The existing septic system that's positioned between the two cabins would be abandoned, and a new septic system would be installed, for which we've had a perk test done on it to make sure that we had adequate real estate and for drain field and for displacement. So as far as again, placement of the building, it's not being positioned in a manner that it's going to encumber any view of adjoining neighbors or anybody behind it. And the property is all owned, the other cabinets on the property is family member. So that's the rest of the information I believe is in the packet and certainly can't be helpful.
So to clarify, is the cabin to, which should be the north, right?
That would be north, yes.
590 square foot cabin, you saying that was going to be removed?
No,
or-
that one stayed.
Yeah, okay.
That's another family member. That one stayed.
Yeah.
And that's the reason we're here for a variance, because we don't allow two dwellings per
correct,
parcel,
that's-
they don't-
yeah.
they don't pay more. Yep.
And in terms of the other things, we're sitting at just over 21% of impervious surface area. And I'm sure that the county will be wanting to design their own plan for how to handle that condition, but what they're to do is to have on that new dwelling, have gutters on it, directing water away from the lake and then into either rain gardens or rock pits or some means of extension pond for the runoff from the hard surface of that building. The existing driveways are not impervious. Just here the driveway.
We usually count all the driveways as impervious for the simple reason that it'll eventually gonna get paved or concreted or gravel. And then it becomes impervious, and then you're more over than what you were. So, I mean, even though it is pervious surface now, usually we try to take that into the account of that percent.
And they can go up to 30 without a variance, so if they're only at 21, they still have 9% to work with.
Okay, and Emily could take a look at that
Yep.
when she comes out today.
Yeah.
Okay.
So it's not like they're bumped right up to the max right now, so.
So the 110 feet of lakeshore includes all the property there. I mean, both cabins. Right?
That's correct.
Yeah, well, I think the lot's about, 92 feet, is that correct? Backside is?
Something like that, yeah, it's about 100-foot wide lot or something, yeah.
Yeah, 110. We just you had on your chest.
Oh, yeah, 19, I didn't see they got a dot there.
And the front will be just a vault, Chuck, and the back will be a loft area with sleeping or something. Up above.
Yes. Then dormers on it.
Yeah, I mean, I looked at the plans, looks real good. I don't know, maybe you should hire a better draftsman.
Anything else you have that you want? Any questions you guys have through the applicant while we're here? If not, you can head back and we'll open the public hearing.
Thank you, Chuck.
This time we'll open up public hearing variance 2313 Bergstrom. Any comments from the people in attendance? Any letters or anything that was added that we don't have in file, Jason?
No.
Hearing no comments or questions, we'll close the public hearing 2613 and deliberate amongst ourselves.
So the 30% impervious is because of the two dwellings there? Or,
Goes by lot.
We're at 21.
right, but you said it could be up to 30.
Yeah, that's what the state law standard is for any parcel can go up to 30% impervious.
That was 15.
15 with no mitigation,
Yep.
then you can go up to 30 with mitigation doing the rain
Up to
gardens.
30,
Yes.
as long as you,
Do mitigation. Yep.
Two points of mitigation is pretty good, too. Better than rain garden. Right.
Yes.
The applicant already mentioned that they're willing to do that.
And they're gonna do a new septic, right? You know what Chuck said, put in a new septic, it's, yeah. I really don't see any problem with this. This isn't affecting the neighbors. This isn't affect, you're not gonna see it from the lake. It'll be a nice little upgrade. We get a new sanitary system. And I think it's a win-win to upgrade our sanitary systems to keep that out of the lakes.
and once again, a permit ahead of the.
And permit ahead, yes, so that's always a plus.
Do you have anything?
No, I don't see any problem with it.
Said, see, unique, it's like that 75 is just right on that addition thing, it's just cool. It's interesting, it's like, you don't get that perfect very often.
No,
Okay, where's my agenda? Yep, this is- I'll entertain a motion then on 2613.
I would make that motion for approving variance 2613 Bergstrom.
Motion by Daniels, do you have conditions that you want to state with it?
There are 6 conditions that are mentioned from staff comments. The shoreline restoration should be made part of the approval since they have approximately 1,400 square feet of improvements within the lake setback. The current standard for items under the 59.6921B provision allows a viewing access corridor 30 feet per 100 feet of shoreline, to a maximum of 200 feet of viewing access corridor. They have approximately 110 feet of lake shore, so they would be allowed 33 feet of viewing access corridor. The buffer depth shall be at least 37.5 feet from ordinary high water mark. Gutters and downspouts on the new dwelling with the water directed to rain gardens and or rock trenches. This is to offset having approximately 1,400 square feet of improvements within the lake setback. 3 sanitary system evaluation to be done for the system of this parcel. Obviously, they've talked about removing the existing one, using a licensed plumber submitted to the county by 10/1/2026 or prior to land use permit being issued, whichever occurs first. We'll need 2 points of mitigation. We're going from 17.5 impervious to 21.5 impervious. Land use permit to be obtained prior to construction. Follow all local, county, state, and federal requirements for this activity.
I have a motion and a second by Schmidt, right?
Yep.
Yep. Any other discussion on the motion with the 6 conditions? If not, all in favor say aye.
Aye.
Opposed? Motion carries to approve variance 2613 Bergstrom with conditions as written.
Ones that have already had your variances, you don't have to stay unless you want to. You're free to go.
Dramatic pause.
Oh, well, you'll be here for a little while then.
At this time, we will hear appeal 2601 Town of Oakland to appeal a decision made by the Land Use and Information Committee in reference to CUP 2519. At this time, this will be a little more lenient than obviously the 3 minutes and stuff like that. I know you guys go by the hour.
Thank you for recognizing.
No,
Jason, did the committee get my
Yes,
May 28th letter?
yes. You should have gotten an email from me with his letter. Yep.
Perfect. Thank you. All set? Well, great. Thank you. My name is Nick Vivian. I'm an attorney with the Eckberg Lammers Law Firm, and I serve as the town attorney for Oakland. And this has been before the town for quite some time. And the town has taken a very clear position on this conditional use permit. And the amendment to the change in the terms in the conditional use permit. And it has been opposed to the changes requested and the changes that were approved by the Land Use and Information Committee. The town demands a reversal of the committee's January 6th action approving CUP 25-19 and the restoration specifically of condition 7 to that conditional use permit. CUP 21-19 granted on August 3rd, 2021, added one site to the park on the express condition that this expansion site will be the owner's residence, not rental property. The committee's January 6th vote arbitrarily approved CUP 25-19, removing that very specific provision, that condition number 7, over the town's objection. And despite the applicant's non-compliance history, including failure to complete required inventories and sanitary servicing timelines, and converting the condition 7 site into a rental. County Corporation Council weighed in with a memo dated December 29, and that memo contains significant and fatal legal errors, which I'll talk about in a second. But most importantly, the memorandum erroneously recast condition 7 as an impermissible regulation of private rent. It ignored the record showing repeated violations, and it discounted comprehensive plan compatibility and density guidance. These contentions are soundly refuted, directly refuted by Wisconsin case laws. So this board, as you know, sits in certiorari on these types of cases to correct errors made by the committee or to affirm decisions made by the committee. Substantial evidence in the county's record not only supports but requires a denial, as condition 7 was central to the 2021 approval. The applicant has not complied with the multiple CUP conditions, and removing the condition number 7 rewards violation and undermines the ordinance's CUP standards and plan guidance for rural mixed-use hamlet areas. Accordingly, the board should grant the town's appeal, overturn the committee's decision, and reinstate condition 7 with explicit findings. And I just want to talk about a few things specifically. I'm a municipal attorney by trade. I represent towns and cities and occasionally serve as special counsel to boards of adjustment and in these types of matters. The facts matter. And at the board, the Land Use and Information Committee proceeding, there was a lot of testimony about why this new CUP was needed. The reality is, it wasn't. The reality is the applicants just didn't like condition number 7 that was imposed, that expanded the use of the park, added a site, but it added a site on the condition, the express condition, that that site be owner occupied and not rental occupied. That was a material condition central to the approval. And the applicant came back this time around and said, well, we don't like it. We want to do something different. So you should remove that condition. That's what this is all about. There was a lot of testimony about a garage and the renter's desire to build a garage. That's understandable. The committee actually discussed a proposed resolution which would include creating a separate parcel for that garage. There was a motion before the committee to move in that direction, and that motion failed. And so, what is it that the committee actually relied on for its authority to remove this condition number 7? We don't know, because they didn't make findings. They didn't really think through. It was more of a landowner's rights discussion. And I get it. I understand it. That being said, that's not what the law in Wisconsin is. The law in Wisconsin is that once you have, well, the law in Wisconsin is in order to impose conditions, the conditions have to bear a reasonable relation to the use of the property. And so the converse is true as well. In order to remove conditions, you have to have some rationale. You have to have some reason as to why that condition should no longer exist. So when this comes before the town board and the town thinks about this, the town says, yeah, we're okay with the mobile home park. We're not crazy about expansion. Our residents don't want expansion. The CUP, the last time around, was amended to change in order to add this one other site, but there was an ownership condition. I want rental to expand, but we'll allow for ownership. That's material. That's central. And so when the matter comes back before the Land Use and Information Committee, and there's all this conversation about rental use, and they say, well, what's the big deal? Well, the big deal is that the town residents and the town board don't want expansion, which is why this condition was imposed when this conditional use permit was approved. And so that becomes the center of the discussion here, and the center of your consideration. When you look at the Land Use and Information Committee's decision, what evidence, what rationale, what reason did they have for removing condition number 7? It's not in the record. You won't find it. And so that's why the town has filed this appeal. It's not often that towns spend their own money to appeal decisions of the county board. Certainly they have a vested interest in zoning. The county makes good sound zoning decisions in the town gets to provide input. But it's not often that the town then elevates and escalates an issue like this to the Board of Adjustment, because we've had a really good working relationship with the Land Use and Information Committee. Yeah, and so here we are. So that centrally is the violation in the record. The Land Use and Information Committee ignored these non-compliance issues. You can see them through Mr. Town's staff report. They're in there. The town or the Land Use and Information Committee didn't really give credence to those violations. And then this concept, as we think about it, the comprehensive plan should really guide use. When we think about the conditional use permit that was originally granted, that ownership provision was central, because there was an acknowledgement that an owner could and probably should live on the land. That makes reasonable sense. But there was no desire to allow that use to expand. So that conditional use permit, when it was approved, made a lot of sense, and for the most part, I think complied with the guidance of the comprehensive plan. Here now, the Land Use and Information Committee is removing that condition, allowing another rental unit, which again, from our perspective, continues to violate that comprehensive plan. So all of these things are major issues and become, I think, a real challenge for the committee's decision to remain as is. Again, it's your determination on certiorari to determine whether substantial evidence supports the committee's action. It's just not there. Wisconsin statute 5969 sub 5E sub D provides that once granted, a conditional use permit shall remain in effect as long as the conditions upon which the permit were issued are followed, but the county may impose conditions such as the permit's duration, transfer, or renewal, in addition to any other conditions specified in the zoning ordinance or by the county zoning board. The statutory framework treats conditions as load-bearing elements of the permit. Removing them entirely, particularly a condition as central as the owner occupancy no rental restriction that formed the key part of the original CUP, is not a routine administrative act. It's not something to be taken lightly, but it's a substantive land use decision that must rest on independent evidence and legal grounds. And the Court of Appeals emphasized in a case involving Burnett County and this Board of Adjustment that conditions must be reasonably related to the legitimate goal of the ordinance and that their modification or removal must have a rational basis. So again, I would ask you to take a look back at the record to see whether there was a rational basis for removal, whether there was substantial evidence and not just opinion and not just testimony and a desire to build a garage or to do something different, but actual evidence that the condition itself was no longer needed. I think what happened, and I don't fault the committee, I think the committee looked at it and said, well, there's no substantial evidence that building a garage would be harmful to this particular site. There's no substantial evidence that, ultimately this is going to create a problem. What they needed to do is they needed to look at it and say, what's the underlying reason and rationale for this condition number 7? Why was it imposed? And is there a reason that we should change it? Is there a rational basis? Has that original rationale gone away? It simply hasn't. There hasn't been a change other than the desire to build a garage and to do something different with that site. And so from that perspective, there is no rational basis. There is no evidence. And while perhaps the committee was well-intentioned and well-meaning, it doesn't meet the standard that is imposed by the law. Approving a CUP change that effectively rewards non-compliance with existing permit conditions, and this goes back to the failure to comply with all of the conditions, fits squarely within the definition of an arbitrary and capricious action because it becomes unreasonable or without a rational basis and represents the body's will and not its judgment. The town of Cedarburg versus Shuzek is the leading Wisconsin case on this principle, where the court held that the property owners may not receive the benefits of the CUP for over 4 years without accepting the burden of compliance with its terms, because the conditions were the consideration for granting the CUP, in this case by a town, in the first instance. And the court further held that non-compliance with the terms of a CUP is tantamount to non-compliance with a town ordinance. And a committee decision to remove a material condition in response to or following the permit holder's non-compliance with the very condition is the antithesis of lawful deliberative judgment. And so you have case law that's directly on point. Corporation Counsel's opinion that's provided in your packet it's a high level discussion of a few different points involved. But again, we think the Corporation Council just got it wrong in this case. The memorandum asserts that there's no substantial evidence that denying removal of the condition would affect health, safety, welfare, or economic prosperity. And again, that's not the question. The question isn't, would denying this request to remove a condition have a negative impact on health, safety, or welfare? The question is there substantial evidence that would justify the removal? Have the conditions changed? Have the circumstances changed? They haven't. And so the premises, the basic premise of her argument is misplaced. Secondarily, she takes the position that condition 7 really isn't a land use related condition, but more so a condition on whether you have to live on the site or not. It's just incorrect. I mean, this is the condition says effectively that this particular site needs to be owner occupied. That is a use condition. How can the parcel be used? It needs to be used by an owner occupant. And so her opinion, which indicating that it has no land use impact is wrong. And then finally, her claim that the county lacks the authority to impose conditions affecting the financial relationship between the site and the park, again, it just takes a look at this from the wrong direction. So while we understand that there's a lot of focus on what the particular user wants to do with the garage, it's just all misplaced in terms of the central question. And clearly the county has a history of tracking this property, tracking the use of the property, tracking the permits that go along with this property. It can absolutely track the land use permit and whether the owner occupant is living in this property is a central premise of this particular CUP. And so it's hard when applicants step up and testify and want to use their land in a particular way. And this is not the average case. This is not somebody coming in and saying, I want to do something, you should grant me a permit. This is an applicant coming in and saying, the permit in place, I want you to remove a material condition. All right, so it's kind of the opposite of what you normally see. And it's hard, it's difficult to understand where you have to apply those tests. But I asked this board to really consider whether the committee really examined whether condition number 7 was central and whether it was important, whether it was critical, and whether there was any evidence in the record to suggest that it should be removed. I couldn't find it. And that's why we're here. And so we've included some proposed findings in my letter. We've included a proposed order. I appreciate the time that you're taking to go through this. It's an important issue for the town, obviously. And I'm happy to answer any questions you may have.
I'll ask a question, just reading through the packet, and again, I'll state I'm not an attorney. I always say every time I hear from one, it makes perfect sense until you hear from another one. But you mentioned circumstance didn't change. Well, we did have, if I'm not mistaken, the parcel was sold. So even though the CUP was there, now the owner operator wasn't living in the unit, and I think it's been multiple years since that, if I'm reading that information correct.
I think that's true.
Correct.
That creates a zoning enforcement issue. Right? I mean, that and the town doesn't have the authority to enforce its zoning code. That's the county office. And so, you know, I think the county office's response here may have been to say, well, one option you have is to apply for an amendment or for a new CUP, which is fine. We're not arguing, the town's not arguing that they didn't have the right to apply for a new CUP or the right to change it. There's just a high standard in order to change it, right? And so that standard is then to come in and say, okay, well, you know, you need to tell us why owner occupancy should not be required. That specific discussion really didn't happen, right? Other than, you know, maybe the board looked at it and said, well, we just don't think it's important. Well, again, it has to be substantial evidence. It can't just be opinion. It can't just be speculation. It has to be, you know, here's why we want to get rid of this. Here are the reasons. The committee have a discussion and make an actual determination that that condition number 7 is no longer relevant. And there's not even really much in the record, to my knowledge, where the committee took the town's comments into consideration in great detail. And I think, you know, one of the things I give the county great credit for, oftentimes in particularly variance cases or other cases, is you get the town's opinions and they mean something. And if there are questions that are raised, they are examined and evaluated, and then the county makes the best decision that it possibly can. And that really didn't happen here. I don't know why. I'm not going to speculate. But the reality is that the town had some serious concerns. We briefed them. We submitted the information. And there was a viable option on the table, and that viable option was to create another lot. And the town's fine with that. If that's the direction that the county wants to go, the conditional use permit runs with the land, runs with the mobile home park, right? So despite the fact that there was a change in ownership, the conditional use permit continues to run with the land. But if the folks who own the garage want to create a separate parcel, and that is outside of the conditional use permit, fine, the town would accept that particular course of action. That was an option that was on the table, that was considered by the board, and it didn't pass. So that's where we sat. So they had that conversation and they looked at it, and for whatever reason, the town boards or the committee, had that discussion and decided against that particular option.
And I guess I'll bring up my understanding of it. We went to, if I'm not mistaken, is there a 10 acre minimum if they were to get a new parcel? And then, because when I read through the document, that's what, like I said, I know that option was discussed. Craig Conroy chaired, talked about that. He even highlighted that there's a good chance this, if we move on with this, that the town of Oakland may not be thrilled without, but I don't believe that there was a legal way to make that new lot. Because then they went from what, 19 or 20 some acres down to 14, because there was another land transaction that decreased the size, which increased the density management side of it.
Well, the way to deal with it probably would have been with the variance. Right, so.
Yes, the new lot would add a specific variance because of it didn't meet current criteria, but
Right.
I'm, you know, like, I don't wanna speak for the land use committee, but they were probably like, well, that, you know, this is a unique case in the sense of with the land transfer ownership of the typical resort. If it was the original owner that lived in there and just said, well, now I'm moving out and I wanna then rent it and add it to the facility, that's one thing, but a lot of times we get caught where circumstances may necessarily haven't been written before.
Yeah.
Or stuff like that, so.
And I would agree with that. And I mean, yeah, the committee was probably caught between a rock and a hard place, right? You know, on the one hand, you have the law, and the town is here saying, well, you can't do this absent really good reason. And on the other side, there was an option, a path, you know, maybe more difficult, maybe some risk to it, maybe looking at another parcel and then going through the variance process, which would have come back through you anyway.
Yep.
And I think the county has just, you know, being here tonight and seeing some of the other proceedings, county has a pretty strong record of granting variances where they're justified. I don't view that as a particular risky proposition, but I think the committee probably looked at it and said, well, and supported by their attorney, no harm to health, safety, and welfare. We're okay removing condition number 7, and we're okay making this not an owner occupied site. The problem with that is that it directly conflicts with and contradicts Wisconsin law. So while I understand the thinking that went into a path that perhaps, you know, met the least resistance, I think the challenge is that it lies in the face of Wisconsin law. And when you look at the case law on these points, at least from our perspective, the committee should have looked at it and said, there is an option. yes, it may require a variance, go pursue that option. And then if you're not successful with the variance option, then come back and you can continue to pursue this CUP, and you can tell us all about your substantial evidence that would warrant getting rid of this condition 7. But I think the committee, and we did this over 2 hearing dates. There was some time that elapsed. My guess is the committee felt some pressure to make a decision and looked at it and said, well, we're not going to make this poor applicant go through the variance process and then come back if that fails. We're just going to approve this conditional use permit. I don't fault the committee for doing that. I just don't think it was right. And I don't think it complies with Wisconsin law, because the case law is very, very clear that you have to have a rational basis. You have to have a reason to remove that condition. And there's nothing in the record that would say they looked at it and said owner occupancy is not important. In fact, the town thinks owner occupancy for a mobile home park is really important when you've got somebody that is managing what happens on site, particularly if there are issues, particularly if a septic backs up, or if there are other issues that need to be addressed. Having an owner occupant on site, if you're going to have anybody on site, you might as well have the owner occupant on site.
Is there a definition of owner then? I mean, is there a owner? Are there a group of owners? How would you describe who could be there as not a rental, but as an owner? Would it be an owner's rep?
I suppose potentially I would read it to say the owner, him or herself, so whoever owns the LLC that owns the park. I don't, and again, I'm on your side of the table a fair amount. I don't like to start to read into things and say, well, maybe we'll give them a little more latitude, because that gets abused quite often. And so, I would quite literally read it to say the owner, who shall be a member of the entity that owns the group that owns the mobile home park.
Any questions you guys got?
Who's in it now? I don't know.
I am.
Okay. Are you renting it?
No, I own a house.
She owns a manufactured home. It's there.
But she's not the owner of the mobile home.
Okay.
No, she owns, well, okay, it's technically a manufactured home. She owns the manufactured home. She doesn't own the.
She
park,
leases space and
but She owns the
like
manufactured home.
how they operate, yeah.
Correct.
Yeah, she is, yes.
So I super appreciate it. Thank you so much, Nick. We'll probably ask you to come back.
Perfect.
But we'll do both, and then we'll try to hear all points, and I'm sure I'll think of another question that probably don't make sense.
Thank you.
Okay, thank you, everyone. Thanks for your time. Thanks for being here. My name is Cal Tillish. I'm an attorney for Wildwood Estates, the owners of Wildwood Estates. Andy Friedman's the manager. It's technically Yellow Lake MHP LLC that owns the manufactured home park. And there's a difference between mobile homes and manufactured homes. So I try to keep that kind of straight. I think the county's, the county committee, the county's land use and information committee decision was absolutely correct. I think it was well supported by the law. I think it was supported by the facts. I think county corporation's opinion further backed it. And I think it was well discussed. He thinks it wasn't. I've looked at the committee review. I think it was discussed. I think this is a case, maybe a little sour grapes or whatever, where maybe the town wanted the county committee to rubber stamp the decision and they didn't. I mean, I see a little bit of that in there, but the county doesn't have to rubber stamp the town's decision. We have a federal republic where we have a hierarchy. So the Constitution of the United States is prevalent and prevails over state. The state law is prevalent and prevails over the county, and the county has prevalence and can prevail over anything that the town does. And I would agree with counsel when he cited Wisconsin statute 59.69. That's 2017 Wisconsin Act 67. And the cases that he cites in his letter, I believe all of them predate that change in the law. And that law gives county decision and right to control or not necessarily agree with what the town has to say. He's correct that there's some you need to have some substantial evidence. And the county can impose conditions, and I think the substantial evidence is there. And the first thing I'm gonna start with is your question. Because the specific words in this number 7 in this cup was this expansion site will be the owner's residence, not rental property. It doesn't say the park owner's residence. It says this expansion site will be the owner's residence, not rental property. So first of all, you got to understand that in the law, there's a law that says generally you have the free use to use your property. Okay, that's the Cohen case, which is 74 Wissahickon, 87, 1976. Or what I like to say, the tie goes to the runner case. So in baseball, if the runner and the ball get there at the same time, tie goes to the runner. Well, in land use and use of what you own, tie goes to the owner of the property. That's where it goes. I wasn't asked to look at it, but when my client bought this park, if I'd looked over all the documents, I would have said, hey, as to this, I call it parcel number 32 or the 32nd one that was added. It says this expansion site will be the owner's residence, not rental property, meaning you can't own it and rent it out to somebody else. It has to be owner occupied. And that's what it was when this, I'm going to say their name wrong, but I think it's the Sabraka. When my client bought the park, the Sabrakas were owner occupants. And I think the owner goes to the owner of the dwelling unit. And it's a little bit like a condominium. So if you buy a condominium, you don't own the dirt underneath it. You own what's inside the four walls. Everybody calls you the owner, even though you don't own the dirt underneath. And then you pay condo association fees for common area and all that kind of stuff. So I actually think the Sabrakas are fine living there with the way this was written. I really do. But secondly, looking again at the whole record and looking at what that committee did, and I think the committee considered things left, right, upside down, and backwards. I think they considered it great. I think their removal of number 7 absolutely was not arbitrary. I think it was well advised. I think it was well reasoned. County Corporation Council agreed with it. And the landowners have certain free rights. And here's the thing, from the policy, when I'm looking at the policy of this, there was a decision to expand this from 31 to 32. Well, you still have 32 living there. You're not expanding it to some other bigger number. You had 32 people living there happily. And now you have 32 people living there happily. And holy smokes, I struggle with what the town's remedy is here for the Sabrakas, because is it to make them homeless somehow? Is it to somehow kick them out of their dwelling where they live? I don't think that would be legally right. I don't think that's a good policy. I don't think there's any equity there. And again, the law favors the free use of the property. So I don't see a problem here. I think that the land committee, the county land use and information committee, that's a long term. I think they considered it all well. I think they reviewed it all well. And I think it makes a ton of sense. And I know part of this came up in conjunction with the garage, my understanding that was built, and most people tend, like your earlier one today, tend to like to have people put stuff in a building rather than in a tent outside. So that made a lot of sense to me too. And I'm not aware of any that I could see in the record of any violations by the Sabrakas. And that's what this really gets to. It really gets to their home and their use and ownership of their home. And if the park needs to have a permit done or was a little late on something or whatever, okay, then, we got to deal with that. And I don't think there's any violations by the folks who live there, who own their home, own their unit. And I think are just valid, good people who, quite frankly, it's getting difficult to get this type of affordable housing for a lot of folks. It really is. So I think the committee, the County Land Use and Information Committee's decision is well reasoned and sustained and should be sustained. And the Sabrakas should be allowed to keep their house and continue to live there.
Any questions or thoughts or comments from you on that?
The property that their home is on.
Yeah.
Is part of the,
Part of the
how
full,
about the adjacent property to them?
correct,
All of that
yeah,
as well?
yeah, it's all part of the
Because it
same.
originally was a big, like 26 and now it's.
And I don't know if it was a lower number at one point, but this one, it went from 31 to 32.
Yeah, and then I think he's just saying the acreage, it used to be a 26-acre parcel, then it
Down
got
to 14,
revised down to 14.
Down to
There's
14.
a lot of discussion about how many buildings on so many.
The
acres.
density and all that stuff,
Right.
yeah.
Yeah, and those are always good legitimate discussions, but it kind of looks to me like when they went from 31 to 32, it looks to me like the decision was made that that density was okay at that point. I realize there was a different person living there, but it was. And it's not a huge change. I mean. That's a beautiful garage too, by the way.
Cal, thank you. Like I said, we'll probably ask you further questions down the road. I guess at this time, the committee can have some discussion as to the initial presentations there. Yep, certainly.
Well, so those were attorneys.
Correct.
For each side. You haven't opened the public hearing yet.
No.
You want to do that before you start having
Yeah.
other people testify? Any comments?
Yeah.
Mr. Chair, could I respond to the comments that were made before we open the public hearing?
Yeah, sure.
Thank you, and I won't take a lot of time. I just want to make sure for the record that the board knows and understands this isn't about Sabrakas. It's not. And when council says this expansion site will be the owner's residence, not rental property, it is rental property currently. He says it's kind of like a condo. It's not a condo. They own their house, but they don't own the land underneath it. Okay, so they rent the land underneath it. It's owned by the LLC that the land is, so they have rights to use it. But they don't own the land. This is exactly what the CUP was intended to avoid or to eliminate. Additionally, they can't apply for a conditional use permit. They're not the owner. That's why you had Yellow Lake MHP LLC apply for the CUP and the change, because Yellow Lake MHP LLC is the owner. They own the house, they own the personal property, but they don't own the land, and they are a renter of the land. It's a novel argument, and it confuses a few different concepts, but this is not a condo. They lease, functionally they lease. 31 or 32, well, the CUP says 31 plus the owner, not 32 renters. So 31 plus the owner, acceptable. The owner lives there, the owner's on site if the owner wants to be there, not 32 renters. They say, big deal, not material. We look at it and say 32 is not compliant. The CUP says 31 plus the owner. What's the remedy for the Sabakas? The committee discussed the remedy, and that is with the carving off a lot, make application for a variance. The town isn't saying move your house. The town isn't saying take down your garage. The town is saying follow the law. And the law is that you have a different path, a different remedy. The committee discussed that remedy, and that remedy is to pursue a separate lot with a variance. And finally, no violations by the Sabrakas. Doesn't matter. This isn't about the Sabrakas, right? This is about the entity that applied for the conditional use permit, which is the LLC. The LLC has violations that are unaddressed. And so I just want to make it very, very clear, because I think the committee heard a lot. I know the committee heard a lot from the Sabracas, but it's really not about them. It's about the owner and what the owner is eligible for. And so let's not confuse these concepts. Let's be very clear that we're dealing with the LLC. Thank you.
Perfect, thank you, Nicholas. I will grant you a
Just
short time.
real
to-
quick.
Yep.
Okay, so he's adding words to the conditional use permit. Okay, it says, this expansion site will be the owner's residence, not rental property. It does not say this expansion site will be the park owner's residence. And it does not say what he just said, it's 31 plus the owner of the park. It doesn't say that. It says it will be the owner's residence and not the rental property. They own it. They're not renting it to someone else. And I understand the restriction of you don't want to turn this into a big Airbnb or, short-term rentals or a quasi campground, where you had, 32 owners who were renting it out and moving it all around. This is a stable owner occupied community. And I think it fully fits there. And when he finally said, this is not about the Sabracas. Well, it is. They're seeking to take away their rights to live in their manufactured home the way they are.
Nothing heard. Jason, do you know what page the CUP is written on? I've looked at it. You can find the actual verbiage on that. but-
Well, there's.
I know it's in there, but
My copy, I don't
I
know
got.
what
Before
the.
I just want to read that myself again. I know it's in the packet here somewhere. Multiple times.
Well, on CUP 2119, condition 7, you want the wording of that?
Yeah.
Says this expansion site will be the owner's residence, not rental property.
Oh, there we go. Flip it over. At this time, we'll open up a public hearing for appeal 2601, Town of Oakland.
Hi. I'm Kim Spraka, this is my husband Paul. I've been coming up here my whole life. My parents actually were the first house in the manufacturer. And this is my second home. Now I retired up here. We had to downsize. My husband's sick. So we've always been looking for a place. We love that area. So friends of mine seen house for sale, went down there, looked at it. It, as far as we knew, was part of the park. And it says it's lot 32. The owner of the park sold us the house. So he had a pad poured already for the garage. But he wanted to build a bigger one. When I applied for it, it opened up a whole big can of worms. It wasn't about the garage, it's about the house. I built a 24 by 20, just like everybody else. As you go down, my house sits this way, the other house sits this way, my garage is here, my house is here. Nobody can ever build on this side of our porch, it goes down. Nobody will ever build back there, somebody else owns it. We do not barely have a backyard at all. And as far as where the garage is, the pad's there, my driveway, and I have about 4 feet. That's a whole septic field. So there will not be any other homes put on either side or behind. I just wanted to make that clear. I have people telling me I'm part of the park. I have people telling me I'm not part of the park. When I looked at the papers when we bought it, it's at lot 32. That's all I know. He was the owner. He was selling his hunting shack. It wasn't his residence. He did not live there. I live there, which I think is better. we're our own entity down there, so. I don't know what else to say except for it's not a mobile park, it's a nice senior citizen community, 50 and over. And I want to be able to stay there, and I don't know if the answer is, you know, yes, we pay for the lot rent like everybody else in the park does. I just assumed that was how it went. That's how it's been since we've been in it over almost 2 years now. So, I wanted to build a garage. I've been renting a storage unit every month. So I built the garage. And that opened up this whole can of worms about owner rental. Buying a house. Nobody else owns the land that lives in that park, so. I don't know what the big deal is, and I don't understand what they're trying to get out of this, like. I don't understand. What the point of the whole meeting is, I just don't get it. So, but thank you for listening.
Thanks, thank you.
Good evening, everybody. Tim McIntyre, I am the chair for Oakland Township, so I thought this was a perfect time to step up and talk and just kind of cover a few things. One, the township doesn't really feel like this is a sour grapes issue. Going back to the first CUP when it was put in place, the owner, first I'll back up one more step. The only person that can apply for a conditional use permit is the owner of said property. I can't put a gas station on each of your properties. I can't get a conditional use permit to do that. You would have to do each of those things. So when we say owner, we're talking land, the land owner. Going further with that, I think one of the interesting things is the initial CUP that we had, Mr. Dubois was involved with that. I was on the board at the time, and he knew that that was his residence. He put a private septic on it and he put a private well on it because it was not part of the park. There was capacity for well, there was capacity for sewer. It was separate from the park specifically. I think that's important. All three entities that were involved, Oakland Township, the Land Use Committee of Burnett County, and Mr. Dubois, all agreed to the conditions in that initial CUP. So all of us sat there and said, yep, we can agree that this is how we can make this thing work. Now, later on, all of a sudden, they want to change those conditions that we agreed to. And truly, that owner-occupied spot was the linchpin. We did not want 32, 34, 38 sites for that mobile home park. As a matter of fact, we did an advisory referendum in our township, and we asked the people of the township, do you want to see expansions to campgrounds and mobile home parks? 83% of people said no. So the folks living in that community said, we don't want this thing getting bigger. We don't want more and more and more of these things. So again, we went back to, if this is yours, to access your hunting land. And that was the whole reason he wanted that spot there, was to access all the land north of there, which he owned. So he could spend the night there, walk right out to his deer stand north of the property and come back to his spot that night. Which I think is a very interesting thing, how we got from that to him selling this thing when, again, it was never intended for that to happen. Oakland Township offered, at the last land use committee meeting, Oakland Township opened up the door to say, hey, we would consider that variance. We do have a 10-acre minimum for subdivision stuff. But we said we would entertain that if that was the solution to fix this problem. Now, we've turned down many people that have wanted to do other subdivision type things, but we said, this makes sense. This is going to fix this problem and end the issue that would be there. Again, at that point, it didn't move forward from that point. Don Hamilton, one of our supervisors, was at the meeting and offered that. Which again, I think says, you know, Oakland, we're not angry about the fact that this is going on, but again, our folks don't want more of these kinds of things. And I will reiterate the statement too, that this is about the CUP. And unfortunately, the Sabrecas are victims of folks doing things outside what was permitted, what was agreed upon. They're kind of the victim of it. They do own the structure, but they don't own the land. Just like every other person in that park. It's not a rental, but it is a rental. Because every other person pays lot rent. They pay lot rent. You know, if the Sabrecas choose to leave there, they don't have to pay lot rent anymore. Well, then, and they can move, I mean, it's a park model, they can move that off of there if they so chose to. We're not saying they need to or anything else, but ultimately, it is still a mobile home park and it is a structure that can be moved. They own it, but that does not make them the owner of the property. Who is the person that can get a conditional use permit? And again, I think that's the biggest thing that we had is this was all agreed upon by all three parties several years ago. And now all of a sudden there was a change that happened. Questions? Anything?
You keep calling it a mobile home park.
Yep.
By UDC, it's not a mobile home park.
Mobile manufactured.
It's a manufactured home, not mobile. Manufactured home is what UDC calls it.
Yep.
So it can't be, for the record, it's not a mobile home park.
It's actually mobile / manufactured because there are mobile homes in there that have wheels and stuff underneath them. The Sabrecas don't have that, but there are that still have access underneath them. So because that for our ordinance that we do have for the township, it's listed as mobile manufactured for both.
You know, and there's mobile homes in there.
Yes. They still have axles underneath them. Yep, they have skirting around them, whatever, but they still have the axles underneath them, so they could hook a tractor trailer of some sort, uplift it and move it out.
So when the property was sold, was that one part carved out? That he had put his own home and septic and well?
It wasn't a separate parcel. But it used to be where they kept their garbage containers. That's what used to sit there all the time prior.
So
to
that 100 acres was separate completely?
That was a separate parcel, yep. And years ago, we actually, when Mr. DuBois owned the property, we actually asked him to take this parcel or this piece of, structure and make it part of make it a 10-acre parcel because he owned the 100 acres or whatever. At that point, he didn't want, he said he didn't want to spend the money to create that extra 10-acre parcel.
The infrastructure and all that, yeah.
Yep, so, you know, and it would have been surveying and a new CSM and all that kind of stuff. But he did have, like I said, he had a private septic, private well on that property. Because it wasn't part of it.
That wasn't then?
It's land within the park, but it was never designed to be a rental property. But because like I said, they had concrete poured there and that used to be where they actually had their garbage containers in. He moved those out of there so he could put the manufactured home on that spot. So then he could access his hunting land. Yep.
So what is the town of Oakland's solution?
Well, we would entertain and Mr. Hamilton talked about that at the land use group. We would entertain the thought if they wanted to create a separate lot for the Sabrecas and their parcel or their structure, we would be okay with that. We would support that from our end and we would support going to you guys to get the variance for that. Even though it doesn't fit our 10-acre thing, but we do believe that this is an extreme situation. I mean, this isn't the run of the mill thing that happens. But we said, hey, we would entertain that idea and we would support that if they wanted to have that happen.
Well, the cost would boil down on the Sabrinas to create that lot with a surveyor.
I don't know how that would work out. If it would be them, if it would be the current owner that would carve it out. I don't know how that would work. I mean, we certainly said we would entertain that as an option to kind of hopefully help solve the problem.
We may ask you more questions, but being you're in public, thank you. Any other public comments from those in attendance? Any letters, maybe that weren't?
Nothing, you've got everything is in your packet, you know.
Not, we'll close the public hearing and then we'll probably have some questions and conversation with the attorneys as we have, so. Hey, tonight, don't you guys?
Makes it simple.
Still want to see, you read me that verbiage, I'm sorry. Yeah. I'll highlight some of the things being we don't have corporate counsel. Stephanie, that is the Burnett County Corporate Counsel. Her letter was presented in the paper. She can't obviously represent, two entities, so I've never met her actually yet, so. Some things I read, the park was approved to increase from 31 residents to 32 residences, with the condition that the 36 residents remain the owner of the park's residence. That's her verbiage. The conditional use permit modification would not be an expansion of conditional use permit for the park. Instead, the modification would change ownership requirement to one site within the park by removing condition 7. The ownership requirement has no discernible impact, and that has been presented by either side, the health, general welfare, or safety, or the county or immediate area. Arguably, they may have a minimal impact on economic prosperity. The next paragraph is pretty good, but corporate counsel basically recommended removing condition 7. The Burnett County corporate, not ours. We don't have that. That was presented at the time to the 7-member board, land use board, when they went through their meetings with this. And I assume you guys read that. It was nice to see that. I'll be honest, as I try to interpret what attorneys say, one, they do a wonderful job of presenting their cases. So I thank both of you for that, because like I said, the last one that speaks usually makes sense from the arguments and that. One thing that did catch me, and this is something that is above my pay grade, but when you mention owner occupancy, when I wrote it down, that's what I said, owner's residence not to be a rental property. That's something that lawyers will probably fight over all day long in court when you have things. One of the examples that gets to me about how court cases was an inheritance case where they had, I leave it to Bob, Sue, and Robert. And the attorneys argued that because of it was a 50-50 split, not a third split on inheritance. I see that as this issue, honestly, between the two sides. What is the definition of owner on the property per that case? And like I said, I don't know. I would say, let a better judge figure that out than me. I do believe the land use committee voted 6-1 on the last condition for this in approval.
Yeah.
I got a Chuck Anderson, I think, was the one that said, and I think the original one was a 7-0.
I think so.
I'm trying to go off of memory, but it's tough to go with that. The land use is filled with a former county,
Zoning administrator.
zoning administrator, yeah. I was gonna say pot
He's the
specialist, but that's
chair.
what we called him that with Craig. They have a lot of, I feel a lot of discrepancy and diversity on the board to look at these issues and did it. I don't think they did, the land use committee did anything in neglect in approving this from circumstance. I get it's a very unique situation. I personally, and I think Brad, your brain's probably doing the same thing, like, well, can we separate the lot and get an agreement on that? I feel the burden for that would be on the landowner, the person that has to do that, but if the town would do it and it would meet those criteria to separate the lot, like Chairman Conroy said that they initially did. But that's a lot of conditions to this argument that are beyond maybe beyond our scope or control.
Well, and if that would be amenable to both parties, I mean, if that.
Well,
A blank permit for a garage causing all of this. Just seems like there's gotta be a way forward that does not create, okay, we're siding with one of the other, it's like. Cause you could side either way, there's no question about that, I mean, it's just, and then.
I look at, just to clarify, I look at the garage as irrelevant because it ended up being 24 by 24. They approved many other ones.
What I'm
and that-
saying
Yep.
is, that started the whole.
Yes, and we, in land use, we get caught all the time where unique circumstance comes and it only gets caught years later. And it used to be that, you know, garages were on other people's lots. A lot more common until we had the 10-foot buffer on both sides and survey equipment got better. To where now we have GIS and satellite overlay where it's, a lot of people get identified like, whoa, I didn't know that was that close to this. Life does move on, circumstance on stuff. It's at no fault to the current owner and I sympathize for you on this. I think everybody here on both sides is understanding. No one wants to, I don't see the option of we're removing the dang unit and putting it back to woods. I don't think that's what the town of Oakland wants. I don't think that's what the attorney wants. So I'd say have some relief that we're confused in this, but that's like a worst case scenario and I don't think it's on the table from anyone, which is why I believe the board did that in that circumstance, say, hey, when we agree for CPUs or conditional use things of 17, it's all unit based is what our verbiage is. At the county, you approve for 26 units. If there's 26 units, I don't think we necessarily care if they're owner occupied. That doesn't meet some of that criteria or problem there. I don't know. It's very tough. Like I said, both attorneys made an excellent case. I don't want to see anything unfortunate happen in the circumstance. It does make sense to me that if there's, and it sounds like there's an option to create that individual land
That's a
parcel.
compromise that can be met with only going forward with one more variance, which obviously we would be looking at, and if the township of Oakland is okay with that, I mean.
Be land use, look at that, right? Not us.
Well,
Subdivision,
it would have to come,
subdivision variances go to the land use committee. Subdivision variances
it
don't.
wouldn't come back to us for them to try to create another lot, pursue that lot option.
That'd be a matter of either the current owner subdividing it and continuing to rent it, or them buying it and becoming their own.
I did have a question. The attorneys talked about that the manufactured homes on the facility obviously can be moved. How does the Yellow Lake MPH LLC address the garages that are on there? Because those are, like I said, foundation garages that are permanent, that get tied to the property. I know that the county then taxes them on accessory structures, so we get revenue out of that too. But how does the LLC deal with the 24 by 24? Because like I said, it's one thing to say I lost my lease, I can take my home, but this applicant has a garage of certain value tied to land she doesn't own and it was approved, which kind of indicates ownership when it reminds me of our airport where we lease the hangars and they build,
Well,
that.
So I think underneath that thought process, they own the building. If they wanna take the building with them,
Well, by definition, you can move anything with a lever.
but that's the same case with the airport hangars.
Yeah.
I mean, they own the building, so if
Grant them a long-term lease or
if
something.
they don't want their lease, then they have the right to remove their
It was
building.
something that popped in my head about, okay, how are we addressing, because when you looked at the printout sheet, there was many 24 by 24 garages on that are now permanent structures. You would define them as permanent structures, right?
Yeah, I
Because
mean,
we can't tax like every campground that adds a deck, that's a permit for the deck and it's a permanent structure on the facility, even though. And that's why town or the MPH LLC Yellow Lake has to apply for all those garage permits. Okay. So it doesn't matter, it's just on the parcel there, so.
Kind of a weird semantic thing that we're going from 31 plus 1 units to 32 units. It's still 32 units.
Right.
We're not changing.
Like I said, what are you guys' thoughts on, like I said?
Definition of is.
So what would the point of sectioning it out? I don't understand that, because it's still there, it's still, that's what I was trying to ask you guys, what is the point of that? The owner of the park would have to pay for that. And would the point be him
So the
selling?
point would be that it would not be considered part of the park. It would be its standalone parcel.
And I think from our perspective, I mean, just talking about compromise. If they would agree to move forward with the subdivision, that's not the town's issue. The town doesn't pay for it, right? That's, I think council indicated he represents the landowner, or maybe he represents the landowner and the Sabracas, but I mean, that's their issue to figure out. I think we would be happy to continue this appeal. If that's the direction they're gonna go, put a pause on this appeal. Give them some time to go through that process, let them complete that process. And then once it's completed, then we can dismiss this appeal. That's how I would propose to deal with it. No, it's not your responsibility to work out a solution. But I mean, if you're thinking in terms of process, and as Mr. McIntyre said, you know, the town board would still have to have a discussion. Presumably, the application is gonna come to your LUIC, and then the town board's gonna have the opportunity to comment on it, and then the LUIC is gonna have the opportunity to approve it. But if it gets approved, then we don't have to come back. If it doesn't get approved, I don't see the town, based on his representation, saying, no, we're not gonna recommend approval. And I can't imagine that the LUIC would say, no, we're gonna stand in the way. Maybe they would, but then we come back and we have more discussions. But that would seem to be a reasonable way to resolve this on behalf of both the town and the land participants.
I tend to agree with you when you say the semantics of 31+1 versus 32. It's the same density, it's the same use. And it seems trying to carve out separate parcels and carve out easements and all these things is a lot of time and money and effort to end up essentially, from a practical standpoint, in the same condition that we are. And having this, well, I'll call unit number 32 or the Sabracas one, subject to any park rules and regulations to make it uniform, creates a certain, conformity and what she described as kind of a senior citizen affordable housing. It just makes a lot more sense to me. And the chair is saying you could see the argument both way on the wording. That's where I got to the tie goes to the runner law, which in real estate law is tie goes to the property owner for their use. So.
And we just completely disagree with, not with the proposition that the tie goes to the runner. The applicant is the LLC. The application identifies the LLC as the owner. The permit identifies the LLC as the owner. The Sabracas they're not in this. What's interesting is that council represents the landowner, who would be glad to take an affirmation of the LUIC's decision, and then they're good. That's gonna result in an appeal. I'm just gonna tell you that today. That's gonna result in an appeal and litigation with the circuit court. That's gonna probably last for 10 to 12 months. That's where we're gonna wind up if we can't come to a resolution. That doesn't bear on your decision, but ultimately, that's the reality, because we have to resolve this issue one way or another. So, I mean, that's kind of where we sit. So I just don't agree that the tie goes for the runner. This isn't that type of case. This is what does the permit say versus what are you allowed to do application, and somebody's gonna have to decide that at some point.
I don't think the township of Oakland is any different than any other of the townships about the hotbed of adding rental property. Our township of La Follette goes through it. I mean, and when 83% of the residents have spoken, you have to listen to that. And I don't think it's any different for any of us, I mean, that's all you hear, is that if I could open up I was allowed to open up a campground on every 40-acre parcel that I had, you know, they'd be everywhere, you know? So I mean, you could say 31, 32, or that's not the point at all, it's the expansion of any would then, I don't know if that creates a precedence for anybody else, but you could argue that, and so, I mean, just, you know, when pushing it down the road, I don't know, if it's out of our hands, that's not our deal there, but also allowing, you know, it to be kicked down the road, I don't know if that's a good solution either.
Well, I think this is my last 2 cents. As my brains went through this and reading the file, it's discussions we've had on this committee on other conditions that we impose on CUPs. And I've always said, it's like, it's not necessarily the initial argument because we trust everyone that I'm gonna follow these 6 conditions. I think Mr. Vivian says it correctly. The permit was only issued because we said it was an owner occupied unit, and I agree, the semantics of that are something that's beyond my control, but now, no fault of the new owner's situation, but what is it, 6 or 7 years later from the situation? It doesn't meet that condition anymore. So I agree that that permit sounds invalid, because if we impose 6 conditions on a permit, I get the permit, I go function in society for 5 years, and then I'm gonna remove that condition, I'm gonna go pull this out. It's a hard thing to do, but big thing is like this buffer zone that we go. I've met people that are like, I don't care, I'll bulldoze, not, this is in Minnesota, but they're like, I'll pay the DNR fine and I'll do whatever and bulldoze the 35 feet and I'll build my house and then I'll let it grow back up to, or mow it all down again. How do we, if the conditions are what gets you the permit, my argument tends to be, well, if you break those conditions, why, you know, it's like you're accountable. And that is the main argument that I'm seeing with this. That being said, we're not worried about 32 units. I don't think town of Oakland cares that they agreed to 32, the density management there's, the acreage is there. Yes, the original landowner should have bought the dang 10 acres and parceled it out, but woulda, shoulda, coulda's happened in the case, and that's why we're here now. I have no intent or want the situation to where the unit is removed, that by no means, I don't think that'd be fair in any circumstance, nor do I think that is doing it. I believe there is a way to make that parcel and make it work though. Unfortunately, the cost would probably come with, if you can talk Yellow Lake into paying for the survey and the stuff, or it's gonna be on, unfortunately, you, because you own the parcel in question. And when you bought the parcel, you didn't know that there was conditions there that you didn't meet. And that's not fault of your own, but that's what the CUP was, is the owner operator is what the board approved. And that, like I said, that's the one thing that gets me is the long-term enforcement. If we approve any variances and we put 4 or 5 conditions in there and 5 or 10 years later, 3 of them aren't being met, do we say, well, you know, you were good for a while, move on? That's my big hang up on it. And I, like I said, I don't have any intent on it. I just don't know where you go from here, with that being said. I kind of like the idea of tabling it and see if they can come up with that thing. Otherwise, I look at the county attorneys and say it's, as you go, it's 32 and 32 and it's not gonna change, and we move on. And if they choose to pursue it, I will watch this one. I'd like to know what the outcome of that is. But I don't know.
Would the town of Oakland be open to them parceling off just that half acre or whatever it is? And not requiring them to go to, you know, have a total of 10 acres or?
Yeah, that's what I said. We
Okay.
would support that.
I just wanna be
The
clear
variance on that,
I wanna be clear on that.
There's no way to go to 10. They only
Yeah.
have 14.
But I mean, he's got property to the north or whatever that he.
No.
That's sold to a different person.
Yeah.
Oh,
See, that's why this is that unique situation.
Land to gain anywhere else. Yeah.
We didn't put in the original CUP that if you wanna keep it owner occupied, then you gotta get a 10-acre lot at that time, you know, that could have been done then, but I mean, we do a lot of.
So we're only got 14 acres to work with.
Okay, okay.
And Andy Freeman already owns that parcel, so why would he wanna parcel that? What's the point of that? Why would he wanna pay to parcel that off? Cause he already owns it.
Well, it's an issue. I mean, that's from our perspective, he would do it because it's his issue, right? I mean, he owns the property. The words of the CUP, I mean, if they're gonna matter, then they're gonna mean something and he's gotta take a corrective action. And parceling a half acre off is far less than finding. I guarantee you that.
I was just gonna say that.
That's a cost benefit analysis. Again, that doesn't come to the town, but that's why, I mean, from my perspective, there's a way that we have to do this and then there's a better way, but that better way has to be agreeable. I can't control that. All I can tell you is I think the words of the permit should matter. And I know that we're entitled to a decision, but if they want to call timeout and look at it from their perspective and see if they can work something out, we'd be good with it.
I think we came here to get a decision. It doesn't mean we can't talk, but I think we need a decision. And I will agree that the words of the CUP matter, but those words are owner's residence, not rental property. And the person who owns that is living in it.
And paying rent.
Right, just like the owner of a condominium doesn't own the land they're under, or the owner of the airplane hangar doesn't own the land they're under.
Right, but those are completely different and they're completely irrelevant. Like the chair said, they own the personal property, but they're still paying rent. Like everybody in that park is a renter. They own their mobile home. And even, you know, they put up their garages, but they can take those garages like we just talked about. If they leave, they can disassemble them and move them, but they all pay rent. They don't own a condominium unit. They don't own the ground. They pay rent to Yellow Lake.
And finally, that's the words argument, but your committee, the land use committee voted 6-1 to change it. Okay, and that's an appeal of that decision to you folks. And regardless of how you read the words, they voted 6-1, and I think the record shows that it was well reasoned, well supported. It was certainly supported by council. So I think their decision to change or to remove that is valid and should be sustained.
Running out, I got one right there ready. Committee thoughts, I know, it's tough. The act before us is to uphold the land use committee vote, we do that, or we appeal or overturn the land use committee votes and then figure something else or whatever you have to do. Those are the two options.
Yeah, the third option would be some kind of
Postpone
postpone a compromise, but it doesn't sound like that's on the table or agreeable by both parties.
No.
You could postpone it and seek clarification from corporation counsel or separate counsel or whatever. There is a postponement option, just so that it's clear. I mean, you don't have to take action. You can move to table or postpone to a later date.
Yeah.
If you want to.
I mean, that's what I have written in my staff report that you could ask for guidance or, you know.
The only, like I said, not that it wouldn't be something we can do, but like I said, if we're postponed, it would be, we should be seeking counsel, and that's what you're. You know,
Yeah, I don't think you should just postpone it just for the act of postponing. it.
Correct, that's.
What do you think, Dan? Yeah, it's a position we're not used to being in.
Yeah, and it's not our,
It's not our expertise, it's not up our alley at all.
yeah,
You know, I'm a builder and you're a draftsman, and that's what we deal with. We deal with permits on the lake.
yeah, I wanna look at setbacks and stuff like that, not this.
The unique part about this board, we pretend to be intellectual sometimes.
You could picture and capture the looks on your faces.
Yes, well, it is, it's really hard. I've been on the other side of this table and stuff, and I know how stressful it can be when it's your home or your dream that you have on this stuff, and then we try to read through 168 pages or however many this one was and understand the great legal talk that we get on both sides. We're all human. We want the right outcome. Our county board is good that way, where, like I said, we're not. No one's talking about tear down the place, get rid of it. We only want the 30. I haven't heard any of that language from anyone in this process. Again, we had strong approval for it at the 6-1 vote and previously. With the county's corporate counsel, when I read her letter, it seemed easy if that's the only thing I read. Again, as Mr. Vivian says, I 100% see the point on if the condition of permit is listed and then that condition no longer exists, does it not make the CUP invalid? Cause you get the permit with 4 or 5 conditions, and then if you change those conditions, cause that's one of the future problems I have with a lot of our stuff is how do we enforce our conditions down the road? Because again, when we're talking real estate, we give conditions to put up $1 million homes on the lakes and they get built. And some of these conditions are very minimal in the sense, but now once the house gets built, you know, it's in a dilemma, and it's part of county's problem. How it ain't necessarily the rule, how do you enforce the rule or deal with the consequences down the road? I think the board acted appropriately to say, hey, this solves the problem, it goes away without a whole lot of legal, that what parties choose to do to bring it to circuit court or whatever. If we agree and then it goes to there, then we'll have actual court hearings and professionals that run through this case back and forth and decide those things that we sit here guessing on.
Because it goes back to the very first question I had was, it says owner. There's a lot of interpretations, and I think that's where the crux of it is right there. And so, I mean, you could argue, I mean, they've done a great job of arguing both ways. Owner is what? Owner of the house, owner of the park.
Okay, when you say the conditions, when we approve variance, we put conditions on a landowner. This landowner did not do that. The county board took the condition off. It's totally different than a homeowner not keeping the grass growing or cutting the trees or mowing it. That's different. He owns that piece of property, so he's benefiting from this, okay? County board, like you say, 6-1 voted to take this amendment off, this condition. So it didn't get done by the landowner or the owner of the property. It got done by the county board. So I feel it's totally different than the conditions we put on a piece of property. That's my thought. Might be wrong, but that's my thought.
That's a good point.
I tend to feel that at the county, this land, the land use committee, they deal with this like we deal with setbacks. This is their baby, and if they voted 6-1, I tend to think they must have some validity to that.
I agree.
I do too.
I mean, if it was if it was 3-4 or 4-3, it'd be something else, but they went 7-0 and then 6-1, that seems.
Well, they helped create the statutes that the county, that we all follow, the county set that statutes. And And like one of the attorneys said, it goes from federal to state to county to township or municipality. So, you know, unfortunately, there probably will be litigation, there'll be a lot of cost. You know, on a certain decision, or there's still gonna be costs to the homeowner, but that's not for us to worry about. We're not supposed to worry about cost. Cost does not come into it.
Nice if we could, yeah, come up with a compromise, but short of that, I guess I'm.
And I think the one side sounded like they weren't willing to deal with compromise. They wanted a decision tonight.
Mr. Daniels, you kind of agree with that?
I do, I mean, after I read through everything, I did, between the township and attorney. Certainly weighs heavier than what we were presented with, I think.
That looks different on paper.
Yeah, I mean, I,
Take the person out of it.
you know, short of reading every permit, I scanned it probably 10 times, you know what I mean? Of all the things that we were presented, and then I think this actually said it best, it's like, oh, yeah, one little circle right there, you know, that we're discussing, and it just, yeah, 6-1 vote.
Do I have a motion on the options that are there?
Not worded.
Well, I
I think you're at B.
B or C, right? B.
Yeah. The,
So option A would be if you disagree with the land use committee decision. Option B is to uphold the land use decision. And I don't think, like I said, to delay, I think we settled that argument that whatever, so.
if I wouldn't be here, if that's for the kids.
Yeah. Nope, good discussion. Thank you, guys. Thanks everyone for presenting stuff, and then get to a motion.
I'll make a motion to deny the appeal request and uphold the decision under the certiorari review.
Do I have a second for that motion? Motion by Peterson,
One second.
seconded by Campion. Any other discussion on the motion? All in favor, say aye.
Aye.
Opposed? Motion carries to deny. Thank you all. Appreciate you guys coming, and sorry for the delays earlier on top schedules. IT.
Thank you for your time. You have to give a lot of time for evening meetings and discuss a lot of details of
Small novel.
Oh, we got a lot of documents. There was 6 last week, 5 last month.
So here's the ones from last month to sign. Now this is bone, the patio and the cabinet. This one, this was the fourth, in Voyager Village, so within the limit area. This one is in Siren, the storage container, wetland, private road setback.
Okay.
This one, the garage down at Anderson.
That's true, yeah.
And the small setback.
Tom Anderson.
Yeah, there's trouble down there.
Well,
That's the person that I.
This is the one on.
But a lot of land are one too.
County roads, T, this is the porch expansion.
Bing, bang.
Geez, and who signed up, I'll tell you that. Affordable housing in years.
Yeah.
Yep. Motion to adjourn.
I make a motion to adjourn.
Mitch,
They're
can
working
I have
on
a
it.
second?
But that doesn't help you any.
Daniels, all in favor, say aye.
Aye.
We are adjourned, thank you, 7:58. Hey,
And then I'm gonna give your guys
Yeah.
packets for next.
Becky's scribbling.
month.
Oh, there's more?
Oh, there's more, of course.
I know we can retire after these ones.
December. Of course. There's more. There's always more. So here, each one of you gets one of these lovely binders.
Good lord. I'm gone next month. I'm gone next month.
Get bigger every month.
Here's a couple of trees for you.
Yeah, really.
Some reading material. and you
You're lucky there's 3.5 weeks in between these and I forget, cause I swear to gosh, I'm quitting every time I show up.
Aren't two of you up for the?
I know, I'm expired.
I'm
I
ready.
can't retire.
Ready to retire.
Well, but Jeremy, we're missing. They are, they love this.
I'm trying to.
I want to,
There's a man. The two.
Oh, no, I'm not, no, I'll be here next week.
So it's in the minutes that they would pay.
Yeah,
Oh, yeah.
I'm the secretary. I can't be the president.
So now.
I gotta read all
I wouldn't want that job.
As I'm-
You did a good job.
So there you go, you're getting reappointed.
So if
I-
you need to, it'll be about.
I do want nothing to do with this committee. Every time I.
Yeah.
Ask it, I'm like, okay, I'm gonna try. How many?
Emotion.
Oh, I can't get out of it.
I'm trying to get kicked off with what I say and my smart ass humor that.
Yeah. So you were appointed already about you knowing.
Yeah. No, I loved your points at the end there. Like, that's good stuff, good stuff.
We're gonna vote that way, gotta have some points.